So tell me about the Crady case and what happened.
Janice Crady, her eldest son, initiated, and her daughter, initiated a lawsuit against her in order to get custody of her. They initiated both a guardianship case as well as a conservatorship case, so they would control her person as well as her assets. The point is that Mrs. Crady didn't have any assets other than a single house and a car.
My name is Adam Berman. I work for Thibe, Reike and Associates in Southville, Michigan. I filed a petition for appointment of guardian of an incapacitated individual for Ken Crady and his sister Charlene. Petition for appointment of guardian. Janice Marie Crady is currently residing in a home with her son, Charlie. Mrs. Crady's mental state is deteriorating, and her son Charlie is not properly caring for her medical needs. Pursuant to recent medical records, Mrs. Crady's blood pressure is out of control, and this is because Charlie has disposed of the medication the doctor prescribed for Mrs. Crady. Also, she does not have a regular doctor, so she has been taken to the emergency department because a simple issue has become an emergency because Charlie refuses to address these issues in a timely manner. When confronted with questions, Charlie is evasive and makes it known that he does not believe in modern medicine. Therefore, he does not feel Mrs. Crady should be taking this medication that a doctor has prescribed for her. Charlie has made a point of failing to provide proper care and obtaining the medications the doctor has been prescribing for Mrs. Crady. Mrs. Crady is essentially being held in confinement by Charlie. He has turned off the ringer for the home telephone, and she has no access to a cellular phone. Further, Charlie has placed his name on the title of Mrs. Crady's vehicle and never allows her to drive. Charlie has added his name to the bank account, where the sole income is Mrs. Crady's Social Security and pension benefits. Charlie has been siphoning funds from this account for his own benefit. Further, Charlie has been fraudulently utilizing credit cards in Mrs. Crady's name. Ken Crady was unable to obtain a doctor's note regarding Mrs. Crady's mental capacity and physical condition prior to this petition being filed. Ken is gravely concerned for his mother's care and safety and is asking this court to grant him and his sister Charlene co-guardianship to get her the care and supervision she needs.
She's 93 years old now, 92, I think, I'm sorry. And she lives alone with her son, her baby son, and has lived with him, Charlie, for the last 18 years. But her eldest son, it appeared, had problems with this arrangement and, in fact, sued his mother. Didn't even tell her he had sued her.
I am attorney Adam Berman, and I work for Thibe, Reike and Associates in Southville, Michigan. On March 29, 2023, I helped Ken from Crescent City, California, amend his petition to appoint a guardian. The petition was upgraded to it being an emergency. It was stated that the alleged incapacitated individual was a ward that was admitted to Henry Ford Hospital in Jackson, Michigan on March 27, 2023, for severe chest pains and high blood pressure without a potential discharge date. It is not in the best interest of the ward to be released in the care of Charlie and return home with him due to his influence over the ward that is detrimental to her health and welfare as described in the attachment to the original petition.
Sued her by putting her into her guardianship, right?
Yeah, by petitioning the court for guardianship. And then, of course, she swore out several affidavits saying that, in her opinion, they kidnapped her from her house. And that's her opinion. And they held her against her will for 18 days, forcing her hospitalization for 5 days. You have all of those documents, I think.
I do. what's up with that? That an attorney comes along and helps somebody from California?
I don't understand. Well, I assume you help anyone who will pay your fees, but it appeared that their fees, which were probably around $50,000 more than that by the time we finished the case, had not been paid. The the firm took the case against Mrs. Crady. Unfortunately, however, even in their initial filing, they did not meet the standards that the statute requires. If you're challenging someone's competence, then you have to have a reason. You have to have a psychiatric report or a medical report, like or evidence, like I'm walking down the street naked, or I'm in the park all night, or I don't know where I am, or something like that. You've got to show in that a person is incompetent, and the burden of proof, as you know, is on the plaintiff. In this particular case, none of that proof was ever provided by the plaintiff, but yet the case went on for 2.5 years.
882 days to be exact. Is
Okay.
that crazy?
No, I didn't know that.
882 days for this 90-something woman.
Yeah.
How did she handle it?
How did she handle
Yeah,
it?
how did she handle it?
It was very stressful for her. Her son Charlie carefully monitored her health, made sure she was eating healthy, still took her blood pressure all the time and everything, because she was forced to be at her daughter's home against her will. She wanted to leave. They wouldn't let her leave. So finally, she had what appeared to be some kind of anxiety attack or a heart attack, and that forced them to take her to the hospital. And there, the two children who had taken her up to, I think it was Romeo or somewhere, I've forgotten now.
I think Jackson?
It's near Jackson,
Yeah.
wherever it's near Jackson, had taken her, were forced to take her to the hospital. Otherwise, she would have died, obviously, there at her house. So that's what occurred. They created a situation that has irreparably damaged their personal relationship with their mother. She has said to every lawyer, including her estate lawyer, she never wants to see either of them again. So, but from the court standpoint, this case should have been dismissed after it was filed. It didn't meet the requirements of the statute. Secondly, you had sworn affidavits from both Mrs. Crady and her son stating that what had happened to their mother by the petitioners, that the petitioners had done this to her, had taken her away, held her against her will, forced her blood pressure to rise to the point that it was way out of control, and that it required her hospitalization for 5 days. So all of this was on the record, but yet we still were going forward with the case, which was not a case in the first place.
Well, the other thing, when going through the court records on Wayne County, because everything's on Wayne County records, there was like 4 or 5 attorneys from Thabe and Reiki. Like, they just kept putting a new person on the case.
Right, they did
Was
do
that
that.
frustrating, working with all these?
I argued against 4 different attorneys. That's absolutely true. And although, you know, finally the court decided in Mrs. Crady's favor that she was not incompetent and that she did not need a conservator or a guardian, they still have her things. One of the things that the plaintiff did, and that, as you know from the affidavit, is they took her things. That when they took her up near Jackson, they took her personal things. And one of her personal things, in addition to her teeth, which she never received back, which, you know, are about $3,000 to replace, they took her antique set of Lionel trains. The engines alone, one engine is $8,000 according to, you know, Google and so forth. These are precious antiques that belong to her husband, and she's maintained them and kept them for herself all these years. And so, but her son took those trains and has never returned them, never returned her teeth, never returned anything. And the court was aware of all of this. She even went to court and petitioned for a restraining order against her 2 children. And it wasn't given to her because, quote, there was a pending probate court proceeding, which makes no sense. I can have a pending divorce against my husband, but if he had kidnapped me for 17 days, caused me to be hospitalized for 5 days, the court would have immediately issued an injunction barring him from me, and that itself would have ended the probate case, because you can't have a personal protection order against you legally and then petition for the guardianship of the person. Even if I was married to you, she would have gotten relief. But unfortunately, the courts do not appear to really respect or care about senior citizens and elderly people, or people who are incompetent. They make arbitrary and capricious decisions every day.
When do superintending control to remove Judge Hartsfield, because it was a year and a half, she just kept thinking that this was she was actually helping, in my opinion, those newer attorneys learning how to do the scam. Is that possible to say?
It's your opinion, and there's nothing on the record that probably refutes it, because it made no sense. First of all, I wouldn't even represent a person personally. I had legal services for 16 years. I started the Elder Law Center in Wayne County. I wouldn't even represent a person who had done that to a senior citizen, intentionally done that to them, and they continue to represent them. It's unbelievable.
You got the opinion on July 29th of saying that she's free to go.
Yes.
Did you celebrate?
After a full trial, after a full evidentiary hearing, it was almost 3 days of testimony.
I don't think anybody's actually seen a full evidentiary hearing. That's probably why you got to win. Courts won't allow even any piece of evidence to come on the record.
Well, we had requested a jury trial because I knew that we would prevail in a jury trial, because the system was against her. So the only thing that I felt would have been appropriate would have been for us to put her case, the facts of her case, before a jury of her peers, and she would win, because I had lost all faith in the system, quite frankly. But every motion that we made was defeated. I mean, there has to be 1,000 pages of documents in this case.
So what's your next strategy? Do you go after those attorneys to teach them a lesson?
Well, I think that's what my client wants to do. I won't be involved in that directly, but she doesn't need me to do that. As you know, the system is very clear. Attorney grievances are filed by the client. I'm not the client. So it would have to be filed, of course, by her. And she also wants to criminally pursue both her son and daughter for their actions. And as well, she would obviously have a great civil suit against both of them. But one of them said under oath that he only has $14,000 a year. So what can I tell you? I mean, I don't know how they even got that law firm to represent them.
Well, and the records, I think, show that they're owed at least $40,000 before the trial, before the evidentiary hearing.
Oh, no, almost $50,000. It was 40-some thousand, right.
Before the evidentiary, and so with the evidentiary hearing, another 10, 20
That was
grand.
in December, right.
What do citizens do? You know, we met you, Ms. Bernard, because of the winning opinion, and that you were able to help Mrs. Craddy get out of this guardianship.
For almost 3 years.
882 days.
882 days.
And I've downloaded all the forms. You're right. It's hundreds of pages of forms.
Hundreds.
It's ridiculous. And at the end of the day, at the very beginning, you had affidavits written up. You had the guardian ad litem report.
Right.
But it's almost like the
two guardian ad litem reports both said the same thing,
right.
that she was fine and she was not being abused or neglected, and that she was competent.
My name is Sean Heck. I work for Goodwin, Gillis & Heck Law Firm in Plymouth, Michigan. On March 28, 2023, probate judge Judy Hartsfield appointed me to be the guardian ad litem for Mrs. Craddy. I was appointed by the court as a guardian ad litem, and I accept this appointment. I visited the alleged incapacitated individual on 4/12/2023 at her home on Empire in Lincoln Park. I report to the court as follows. Mrs. Craddy contests the petition. Mrs. Craddy objects to the appointment of the nominated guardian, which are her two children, Ken and Charlene. I, Sean Heck, believe it is in the best interest of the individual to have legal counsel because she objects to the petition. So I have checked the box that the individual will retain legal counsel. I also filed the form Objection to Petition for Appointment of Guardian, signed the Wayne County Probate Court Form 260, and it states the alleged ward, Mrs. Craddy, objects to the appointment of the guardian, and this is my report. I, undersigned, duly appointed guardian ad litem for Mrs. Craddy, an alleged incapacitated individual, and all persons do accept the trust imposed on me as guardian ad litem with reference to the petition seeking appointment of guardian, and do by render my report with respect to said petition, which has been filed in the court by Ken Craddy, son, and to state in relation thereto as follows. The petition for appointment of guardian alleges that Mrs. Craddy, allegedly incapacitated individual, is an adult and that she needs a guardian because she currently resides in a home with her son Charlie. Mrs. Craddy's mental state is deteriorating and her son Charlie is not properly caring for her medical needs. Ken was unable to obtain a doctor's note regarding Mrs. Craddy's mental capacity and physical condition prior to this petition being filed. Ken Craddy is gravely concerned for his mother's care and safety and is asking the court to grant him and his sister Charlene co-guardianship to get her the care and supervision she needs. Per MCL 700.1105A of the Estate and Protected Individuals Code defines an incapacitated individual as a person who is impaired by reason of mental illness, mental deficiency, physical illness, or disability, to the extent that the person lacks sufficient understanding or capacity to make or communicate informed decisions concerning his or her person. I visited Janice via phone on April 12, 2023, and explained the petition and her rights. I advised her of the hearing on April 18, 2023. Janice was aware and oriented at the time of my conversation. She was able to have a complex, coherent conversation with me, and she was able to answer all my questions appropriately. I did not detect any confusion or lack of understanding during our conversation. Janice stated that she does not need a guardian. She objected to the petition. She says that she is still capable of making her own decisions and that she still handles her own affairs. She said that if the court were to determine that she needed a guardian, that her preference would be for her son Charlie or her daughter Nancy to serve, not Ken or Charlene. Janice says that prior to this petition, she had had very little contact with Ken or Janice and that she does not know why they are doing this to her now. Janice says that her son Charlie moved in with her a long time ago to assist her with the needs that she needs assistance with. She says that she does not charge him rent, but that he does help her with paying the utility and cable bills. She says that Charlie is not controlling her life in any way. Janice also informed me that she has retained attorney Linda Bernard to represent her in these proceedings. April 10, 2023, I spoke with Annette Bearden from Adult Protective Services. She has an open referral to investigate this matter. She informed me that Janice had left her a voicemail indicating that she was all right and did not need any services. She asked to be left alone. I was also informed that the Lincoln Park Police also responded to the home for a wellness check and that they found no indication that any action was needed. Currently, it is my understanding that APS does not have the information to take any further action on this matter. On April 10, 2023, I spoke with Sherry from Dr. Zilka's office at Henry Ford Hospital. She explained that they had been providing medical treatment for Janice. In fact, Janice had been seen by their office that very day. She stated that they did not have any reason to believe and did not observe any issues that would lead them to believe that Janice had any type of cognitive deficit. She stated that they did not have any reason to believe that Janice would need a guardian to assist her. The petitioner did not provide any medical evidence that the ward requires a guardian. The ward owns the real property located on Empire in Lincoln Park, Michigan. The petitioner stated that they do not know what the rest of her income consists of. Your guardian ad litem does not believe that there has been clear and convincing evidence presented that Mrs. Craddy is an incapacitated individual It is the recommendation that if the petitioners decide to go forward with this petition, that because Mrs. Craddy objects to this petition, that the matter be set for hearing. I hereby declare under penalty of perjury that I have read the foregoing reports of guardian ad litem by me signed, and that the matters therein contained are true to the best of my information, knowledge, and belief. Respectfully submitted, Sean Heck, guardian ad litem, April 12, 2023.
My name is David Kanan, and I work for Thave, Reiki and Associates in Southfield. On April 17, 2023, I recommended to my client, Kenneth Craddy, to supplement his petition for guardianship and conservatorship. The petitioner, Kenneth Craddy, by and through his undersigned counsel for his supplement to his petition for guardianship and conservatorship, states as follows. 1. Petitioner and his counsel are in receipt of guardian ad litem Sean Heck's report, in which he recommends denying both petitions before the Honorable Court. 2. The companion petitions before the Honorable Court for both guardianship and conservatorship are based wholly on elder abuse concerns. 3. Specifically, Mrs. Craddy's son Charlie begrudgingly takes her to physician appointments, though does not follow up on medical directions given because he does not believe in Western medicine, bullies his mother with respect to finances and supporting him to her ultimate detriment, and creates a hostile environment in which his mother lives in fear and will do nothing contrary to his direction. 4. Mrs. Craddy's son Charlie has lived with her for over a decade. For context, Mrs. Craddy is 88 years old. 5. He has not been employed during that time, has no source of income, does not have a driver's license, and has been incarcerated for crimes related to his belief in the sovereign citizen movement. 6. While petitioner and counsel for petitioner appreciates the guardian ad litem's Heck's efforts, there are omissions and irregularities in his report that are cause for concern. 7. First and foremost, guardian ad litem Heck never actually met in person with Mrs. Craddy at her home in Lincoln Park. Rather, his report somewhat misleadingly states on page 3, I visited Janice via phone on April 12, 2023. Guardian ad litem Heck, on previous occasions, expressed frustration with his inability to schedule an in-person meeting/interview with Mrs. Craddy to both petitioner and counsel for petitioner. Moreover, guardian ad litem Heck emailed the undersigned advising he had spoken with Janice on 2 separate occasions. However, he only seems to list one in his report. 8. Additionally, on page 4 of his report, guardian ad litem Heck states he spoke with Sherry at Dr. Zelka's office at Henry Ford Hospital and was told Dr. Zelka had been treating Mrs. Craddy and she had no concerns with respect to cognitive decline and did not believe she otherwise required a guardian. 9. With no disrespect intended towards guardian ad litem Heck, given that he served a subpoena on Dr. Zelka's office, he should have actually spoken with Dr. Zelka. There is no indication in the report who Sherry is. Nurse, physician assistant, office manager, receptionist, etc. 10. Counsel for petitioner has various exhibits he wanted to attach to this pleading. However, because they include medical records, had some reservations. 11. After calling Judge Hartsfield's courtroom and speaking with Ms. Taylor, those records had been emailed directly to Chambers. 12. Those exhibits include medical records charted by Dr. Zelka in connection with a consultation she had with Mrs. Craddy on February 6, 2023. Notes indicate Mrs. Craddy last saw Dr. Zelka on January 4, 2023 for persistent cough and high blood pressure. Dr. Zelka, at the time, prescribed low pressure, 25 milligrams daily for the hypertension. However, at the next consultation on February 6, 2023, neither she nor her son Charlie is and was always present at these consultations and speaks for his mother, could recall that they ever picked up the script for low pressure. Number 13. Dr. Zelka's report further states, current cough per son had gotten better and then worse again. Discussed that her chronic cough may be related to respiratory, allergy, or heart. Son indicates that they have followed with pulmonary and allergy in the past without benefit. Mrs. Crady states she used to obtain allergy shots and that she did not feel seeing allergy was beneficial. Son concerned as he reports that medication kept being changed. ... Made recommendation for referral to pulmonary and allergy, both of which the son does not appear interested in taking patient to, feeling they are of no benefit. Emphasis added. Number 14. It is disturbing Dr. Zelka in her charting on 2 separate occasions note Mrs. Craddy's son Charlie does not believe her suggested medications and therapies are worthwhile. Number 15. On March 27, 2023, approximately 2 months after the prior medical consultation, Mrs. Craddy was in the Jackson, Michigan area visiting her daughter, Charlene, and petitioner. During the visit, she fell ill and was taken to the emergency room at Henry Ford Hospital. The following is an excerpt from her chart. A rapid response was called at 8:13 for Mrs. Craddy due to bradycardia and mental status change. When evaluated, patient slumped over in bed, however, was able to be aroused and answer questions. She was noted to have new right-sided facial droop that was new from prior and slurred speech. Much of her speech was nonsensical. ... Neuro exam was limited as patient was not following all commands and producing nonsensical speech. Number 16. The next day, Mrs. Crady's son Charlie drove from Lincoln Park to Jackson, Michigan, and was able to convince Henry Ford Hospital personnel he was her caregiver and to discharge her before further testing was completed. These actions show a reckless disregard for his mother's health and well-being, and a complacent, uninformed demeanor on the part of his mother at best. Number 17. On July 15, 2010, Charlie was driving Mrs. Craddy's car. She had accompanied him as a passenger. He did not have his driver's license. He was pulled over in Allen Park. Before the police officer approached the vehicle, Charlie asked his mother to take his position in the driver's seat. They were caught doing this, and Mrs. Craddy was citing for allowing an unlicensed driver to operate her vehicle. A misdemeanor. At the time, Mrs. Craddy was nearly 80 years old. Number 18. Charlie does not have his mother's best interests at heart, and most of the time does not seem to care about her at all. Number 19. Conversely, at best, Mrs. Craddy is completely malleable and defenseless when it comes to protecting her best interest when her son, Charlie, is involved. 20. Finally, Charlie and Mrs. Craddy visited petitioner Ken last year at his home in California. While Charlie was walking on the beach, Janice confided to Ken that she was scared of Charlie, that she was having trouble remembering things, and believed Charlie had opened up nearly a dozen credit cards in her name and put her car and home in his name alone. When Charlie returned from the beach, Mrs. Craddy twice told him he needed to find new living arrangements when they returned to Michigan. Each time she told Charlie this, he laughed at her. Petitioner and his partner are willing to testify to this. Number 21. Again, Guardian Ad Litem Sean Heck never interviewed Mrs. Craddy in person at her home, even though he tried on multiple occasions to do so. While the Guardian Ad Litem Heck states in his report that Adult Protective Services and Lincoln Park Police Department have never found anything untoward while visiting, both entities have described Mrs. Craddy begrudgingly entering the front door with someone speaking behind her as though giving her directions. Number 22, MCL 700.1105A defines incapacitated individual as an individual lacking sufficient understanding or capacity to make or communicate informed decisions. Emphasis added. Number 23. The medical records provided, along with the statement she made to her son, Kenneth, the petitioner, regarding her cognition, demonstrates Mrs. Craddy lacks sufficient understanding or capacity to make or communicate informed decisions. Moreover, her son Charlie, while living with her, is in a unique position to exploit this condition for his own benefit. Wherefore, petitioner for both guardianship and conservatorship, Kenneth Craddy, respectfully requests that this honorable court not adopt the findings of fact or recommendations of the guardian ad litem in this case, and instead grant his petitions. Respectfully submitted, Thave, Reiki and Associates. Attorneys for respondent, David Kanan, dated April 17th, 2023.
My name is Attorney Sean Heck, and on May 15, 2023, I supplied the supplemental report of guardian ad litem regarding the petition for appointment of guardian. I, the undersigned, duly appointed guardian ad litem for Mrs. Craddy, an alleged incapacitated individual, and all persons who may become interested do accept the trust imposed on me as guardian ad litem. I do state the following. The petitioner was concerned that the guardian ad litem did not visit Mrs. Craddy in person. Therefore, I visited Mrs. Craddy in person at her home, located at Empire, Lincoln Park, Michigan. At the time of my visit, Mrs. Craddy was aware and oriented as to the time and place, and she was able to answer my questions. I interviewed her privately in her living room. Her son, Charlie, was present in the home, but he remained in his own room for the entirety of my conversation with Mrs. Craddy. He only came out when I requested that he come out so that I could speak with him. I did not observe any evidence of coercion by him of Mrs. Craddy. Mrs. Craddy objects to these petitions. She denies that she needs a guardian and conservator, and she denies having any cognitive deficits. She states that her only medical conditions are high blood pressure and arthritis. She has prescribed medication on hand that she reports that she takes for her condition. Mrs. Craddy was able to give a detailed recitation of her monthly income, and she was able to tell me what her monthly expenses are. She stated that she handles her own banking and pays her own bills. Mrs. Craddy says that her son Charlie lives with her and that she wants him to live with her because he helps her out around the house and she likes having him there. She states that she had added him to her bank account as a matter of convenience. She stated that Charlie works odd jobs, fixing and tuning musical instruments, and does other electrical repair jobs that he gets paid for. She said that he gives her approximately $1,000 per month as his contribution to their bills. Charlie denies the allegations that he does not believe in Western medicine and says that he encourages his mother to see doctors, and in fact, he is the one that has taken her to her appointments. Mrs. Craddy denies being afraid of Charlie and of being bullied by him. In fact, she says it's the petitioner, her son Ken, and her daughter Charlene that she is afraid of. Mrs. Craddy stated that Ken and Charlene tricked her into visiting Charlene's home and that after they took her there, they would not allow her to leave or to call her son Charlie to come and get her. Mrs. Craddy said that they took her to the hospital and that at the hospital Ken was asked to leave after Mrs. Craddy complained about his behavior towards her. She said that she was then able to return home with Charlie once the hospital discharged her and that the hospital discharged her to Charlie's care. Your guardian ad litem listened to a recording provided by the petitioner. The recording was made, and Mrs. Craddy could be heard saying that sometimes she has a hard time remembering things, but she even says that she will eventually remember in the recording. I asked Mrs. Craddy about this, and she said that she does sometimes have a hard time remembering things that happened a long time ago, but that she does not have any problem remembering who people are or what she needs to do on a day-to-day basis. The recording does not really prove any cognitive deficit. The medical records that are cited all appear to be in relationship to physical illnesses. None of the medical documentation provided suggests that there's any concern that Mrs. Craddy has any cognitive deficits. After Mrs. Craddy was hospitalized, she was stabilized and discharged to her home. When I visited, her condition appeared to be stable, and she reported that she was feeling well. Other than being upset about these petitions, there are allegations that Charlie was driving with Mrs. Craddy without a license and tried to have her switch places with him when they were pulled over with Mrs. Craddy, ending up being charged with allowing an unlicensed person to drive her vehicle. Charlie denies being unlicensed. He denied that the instance happened as reported. He claimed that they were falsely accused by Ellen Park police officer Daniel Mack. He claims that Officer Mack was eventually discredited for filing false police reports, and that this case was eventually dismissed. A Google search indicated that this officer was removed for violating suspects' constitutional rights. Your guardian ad litem was not able to independently confirm that this case was dismissed. Charlie reports that Mrs. Craddy asked him to come and get her from Charlene's house, and Mrs. Craddy confirmed that it was her that requested that Charlie come to get her and take her home. He stated that he requested an officer be present in case there was an issue. He said that Ken waved a piece of paper to the officer and claimed that he had been appointed a temporary guardian and that Mrs. Craddy could not leave. This was not accurate because the court had never made the determination to appoint Ken as a temporary guardian, and in fact, that petition had been denied. Charlie provided a police report confirming this allegation. The petitioner states that I misled the court by saying I visited the ward via phone. I do not know how that is misleading. I clearly state that I visited the ward via phone. This is a current court rule in effect that allows guardian ad litems to conduct visits via phone. The petitioner additionally has concerns that I did not speak with Dr. Zilka directly about Mrs. Craddy. I did speak with an employee of Dr. Zilka's at the doctor's direction and have no reason to believe that I was given inaccurate information. I was advised by Jeanette Barden of Adult Protective Services that they are closing this case because they have not been able to substantiate any abuse or neglect. Your guardian ad litem still does not believe that there is clear and convincing evidence that Mrs. Craddy needs a guardian and a conservator. Mrs. Craddy has stated that she has retained attorney Linda Bernard to represent her. It is the recommendation that if the petitioner wants to proceed because Mrs. Craddy objects, then this matter be set for an evidentiary hearing and that an attorney be appointed to represent Mrs. Craddy if that is determined to be necessary. I, Sean Heck, attorney and guardian ad litem, dated May 15, 2023, hereby declare under penalty of perjury that I have read the foregoing report of the guardian ad litem by me, and that the matters therein contained are true to the best of my information, knowledge, and belief.
And yet Judge Hartsfield just kept it going.
Yep.
How do we get the bar more engaged?
The probate section. Well, first of all, I don't quite understand how it works, because obviously the probate court makes assignments, and everyone gets rich in the process. The guardian ad litem, the attorney, but the person who is the subject of the guardianship, and his or her needs can be ignored, and that's the problem.
You know, we're just looking for solutions, and it's tough. But we're thankful that you stuck with the family. And I heard too, you did it pro bono. Like you just did it because you cared about what was going on with
I couldn't let that happen. As I told the court, I was raised by my grandmother. My mother died when I was 5. She was only 32, but she had a cerebral hemorrhage. But I couldn't let that happen. Obviously, I care because I started the Elder Law Center of Wayne County. I want senior citizens and their rights to be protected, and they are not now. It does not appear to be the case.
Are you familiar at all with Dana Nessel and her elder abuse task force?
No, I wasn't aware of it. But full speed ahead to her in terms of what she's doing. And if anything I can do to help, I'll be happy to.
We love you, Ms. Bernard.
You're very kind. I love you too, Jody.
Thank you.
Thank you.